Hello, everyone. This is Kevin again doing the Worthy Law podcast. This time it is for April 2019. And this time I want to talk a little bit about the motion to dismiss. Last time we talked about the litigation process in general and generally what to expect. And I want to go over this time the motion to dismiss because that's one thing that you can possibly see early in a case. A lot of times you won't see a motion to dismiss. The reason a motion to dismiss is filed can vary. There are a number of different grounds. Sometimes it's insufficient service of process. Sometimes it's lack of jurisdiction. The most common type of motion to dismiss is a motion to dismiss for failure to state a claim. And that's the one that I want to talk about here, because if you're a defendant in a lawsuit, you want to be looking at opportunities to file a motion like this. And if you're a plaintiff in a lawsuit, you want to craft your complaint so that either no motion to dismiss will be triggered, or if a motion to dismiss is triggered, the complaint will survive that motion to dismiss. So a couple things, I don't want to create a long treatise here, but just a couple things about the motion to dismiss for failure to state a claim. The first thing that I want to talk about is that the plaintiff actually has to allege something that is illegal. So if the plaintiff doesn't do that for some reason, the complaint can be dismissed right off the bat. So what is an example of something? I'll give you a simple example. This is probably not the kind of thing you would see in a real case, but let's say you had a plaintiff who files a breach of contract case, and his theory is that you had a contract to sell him 3 horses, but he decided after you signed the contract that he wanted you to include a 4th horse for free, and you would not do that, and so he filed a lawsuit. Well, just assuming that all of that is true, he has no claim because you didn't do anything to breach the contract, because your contractual obligation was to transfer 3 horses to him, not 4 horses to him. So that's kind of a simple example, and it gets around sometimes what you get into in terms of debates about what actually happened. So in some cases, you might have a debate about, well, was the contract to sell 3 horses or was the contract to sell 4 horses? Did the horses actually get transferred, or did the horses not get transferred? Or you might have other issues around that. But if on the pleadings, if as the complaint is written, assuming everything in that complaint is true, the plaintiff doesn't actually allege something that's illegal, then you can get that dismissed. And that's a conversation, I think, if you're on the plaintiff's side, that's a conversation you want to have with your lawyer. Sometimes you might be really upset about something that has been done to you, but come to find out it's not actually against the law. It's annoying, it's maybe immoral, maybe it should be illegal, but it's not actually illegal, and so you can't sue for it, or at least you can't sue successfully for it. So those are some things to keep in mind there. Another thing that's interesting about a motion to dismiss for failure to state a claim is in the fraud context, because fraud has some special pleading requirements. Typically, the only thing you have to do to plead in a complaint is provide a short and plain statement of the relief that you're seeking and the grounds for that relief. But fraud's got to be pled with a little bit more particularity. You've got to give more detail as to who committed the fraud, what they said, when they said it, where they said it, to whom, and this kind of thing. And the courts have had those kinds of rules for a long time. Those apply in contract type fraud, securities fraud, real estate fraud, all kinds of different fraud. So that's one thing there. So if you are a plaintiff in a lawsuit, just know that your lawyer might want to include a little bit more detail in a complaint if there are fraud claims. And if you're a defendant in a lawsuit and you get a complaint and it doesn't really seem to say what the fraud was, it just says that you lied at some undisclosed time and some undisclosed location and said some kind of vague things that weren't true, those kinds of things can also be just dismissed right off the bat. So that's your motion to dismiss. Like I said, a lot of cases aren't going to have a motion to dismiss. In a lot of cases, you're just going to get an answer. The complaint is going to be filed, and the defendant is going to have 3 weeks, typically, at least here in Utah, to answer that complaint, and then you'll move on to the rest of the case. But if a complaint is deficient in some way, the defendant can move to dismiss that complaint for failure to state a claim, or like I mentioned earlier in the podcast, there can be other reasons for a motion to dismiss as well. So that's a little bit about how to do litigation in the Utah courts, and that applies in the federal courts here as well and across the nation. So if you made it this far, thanks again for listening, and God bless.